Okay, when we talk about estate planning, we talk about two basic things. Right? First, we're going to talk about the transition of assets. Right? What do we do with our stuff when we die? The other thing that we're going to talk about is we're going to talk about incapacity. Right? We're going to plan for the unfortunate event of us not being able to take care of ourselves or our property, right? So in essence, when we talk about estate planning, we're planning for those two things. So what I'd like to do is just go through a quick demonstration and show you the different levels of estate planning and how we take care of those two different things. Okay, so in this hypothetical, we're going to have a couple, a married couple, right? We're going to have, this will be Doyle, and we'll call her Dinah. Okay, Doyle and Dinah Jones. So Doyle and Dinah Jones, they're middle-aged. They just about average in life, and right now, this is what they've got. We're going to talk about the transition of stuff. So what kind of stuff do they have? They have a house, right? They've got a car. And they've got some bank accounts. So we're going to draw a bank here. They've got some 401k stuff. Retirement planning, so they've got a 401k, they've got some jewelry, and maybe they've got a piece or two of art here. So they've got some art. And they also have 3 kids, right? So they've got let's see, they've got Dan, and they've got Dory, and they've got Delna. We'll do this at say 21, 15, and 9. They've got three kids, right? Also part of what they've left the world here. So the first level of estate planning is they don't have a plan, right? They don't have a will, they don't have anything written and instructed. They've talked about it, but they never got around to it. So unfortunately, Doyle and Dinah are on a cruise somewhere, right? And they met their demise. Maybe the cruise ship tipped over, and they didn't survive. So what happens? Well, Dan and Dory and Delna, right? They are the presumed heirs. And how do we know that? Well, the state of Utah got together a while ago, and they said, look, for people that don't have a plan, because not everyone will, we need to create a plan. And they did their best that they could, right? So what happens? Probably Dan, he's 21, he's the oldest. He'll probably say, look, Mom and Dad had a house, they had bank accounts and cars. And so he'll try to go to the bank and access funds to make sure Dory and Delna are taken care of, and that bills get paid and they don't shut off the water on them and that kind of stuff. And so we've got Dan right here, and he volunteers because he's the oldest brother and he's capable, and he goes down to the bank and he says, okay, listen, I'm their son, I'm the oldest son, most trusted. I need access to these accounts for my little brothers and myself, or brother and sister and myself. And the bank's going to tell him, look, you're not Doyle and you're not Dinah. No access, right? No money for you at this time. And he says, well, listen, they're dead. I'll show you the death certificates. And they say, oh, okay, they're dead. Well, still, you can't access it. I don't know if you're actually their favorite son, or maybe they made other arrangements, but no money for you. He says, well, what do I got to do, right? He says, well, you need some authority, right? And so what do I got to do that? So generally what will happen right? And this doesn't have to be Dan. It could be Doyle's mom or dad or someone like that. But they will need to get some authority so that third parties, like the bank, like the county recorder when it comes to the house, give them some respect, right? So they run over to the court, right? And they say, look, Your Honor, Mom, Dad died. They can't use that stuff anymore. We need to transition this to the living and wrap up this thing. And the judge, he's going to go and he'll say, okay, you're right, but this needs to be done in order. So first, we need to give everyone notice that your parents have died, right? That includes siblings. That includes potential creditors. It includes everyone that might have a claim on this estate. Then we'll probably have a hearing, and anyone who wants to object or wants to assert a claim, they'll show up at the hearing, and then finally, I'll issue an order, right? And if you are who you say you are, then there shouldn't be a problem, and as long as no one objects to me giving you this order. And this order that the judge is going to issue, we call that letters, right? It could be letters of administration, right? So finally, right, we've got Dan here, and he finally gets these orders. Well, the problem, and then once he gets these orders, then he can talk to the bank, and he can talk to recorder's office and the DMV, and he can start to distribute this property, okay? Well, that's one way to do it, right? That's the no plan way. There is a slight hassle or a process that's involved, right? And we call this process, we call it probate court. And probate court usually takes, on the minimum, about 3 months. All right, if we're talking about time here. And it's kind of expensive. I'm doing several right now, and it costs about $2,500, including a filing fee of $360. So, and that gets to the point where they are distributing these assets. Now, people didn't really love that, right? So what can we do better? Well, if that's the no plan, the next level up is to Doyle and Dinah. Maybe they have a will, right? And in this will, they get to do 2 or 3 things that people without a will can't do. 1, they get to name who their personal representative is. 2, they get to designate a replacement guardian for Dory and Delna, because they're not emancipated yet. They're still kids, right? So they get to pick a guardianship. And 3, they get to decide what happens to their stuff, right? Where do they want it to go? And so in that respects, a will is much better, right? Maybe Dan is not able or willing to do this, and so they get to pick a secondary. Maybe that's an uncle, maybe that's an attorney, maybe that's a respected friend, or someone like that. In addition, maybe Dinah has a sister that's always wanted kids, but she's a terrible person and unreliable, and so Dinah might step up and say, hey, I'll parent the kids, but Doyle and Dinah didn't want them to, and so maybe they make a provision in this will that says they don't get to do that, right? Anyways, but other than that, it follows pretty much that same process. The judge has to validate the will, and then they still give notice, right? They still have a hearing, and then they still issue this order. At this point, the letters are no longer letters of administration. They are letters testamentary, right? And testate is a legal term meaning that someone died with a will or without a will. Intestate without a will, testate with a will. So letters testamentary. Well, that was kind of a long process. People didn't love that. Utah has a rule, though, that says, look, if there's no real estate, and the cumulative value of all your stuff together values less than $100,000, then at that point you can run under the small estate rules, and we don't have to run through a full-blown probate. So these are the two triggers, right? That's what causes probate, when there is real estate or it values over $100,000. And when it comes to any type of property that you have, for Doyle and Dinah, they've got a home, plus they've got some other money as well. So that would trigger probate. Anyway, so people didn't love that. But the main problem of having to go through probate is this big issue of authority, right? Authority, because Dan needed authority so that people would respect him and not feel like they were obligated or liable if they distribute it to the wrong person. So they needed authority from the court. So people said, well, let's not do that. Let's not have people have to sign on behalf of others. And so what we're going to do is we're going to put all of our stuff, right? We're going to circle most of this stuff, and we're going to put it in a trust, okay? And how a trust works is there's three players. There are the grantors, and that's who put value inside the trust. So Doyle and Dinah, in this case, would be the grantors because it was their stuff. So they funded this trust. We've got the trustees, and you can think of these parties as those that manage the trust assets, right? And then we've also got the beneficiaries, right? And these are the people for whose benefit is that who gets to enjoy these assets. So the beneficiaries. Now, for most of the people, just about all the people that I do a trust for, we will utilize at least some form of what we call a revocable living trust. And what that means is in a revocable living trust situation, Doyle and Dinah get to wear all three hats, right? So they get to be the grantors because it was their stuff. They get to be the trustees because they get to manage this property while they're living. And also they are the beneficiaries because while they're living, if they wanted to sell everything and go on a cruise for 2 years, then that's their prerogative. It's their stuff. They can do it. But the difference is in the form of ownership. They no longer own this property as Doyle and Dinah Jones. They own it as Doyle and Dinah, trustees of the Jones, we'll call it the Jones Family Trust, right? So what happens is that when they die, right, when Doyle and Dinah pass, now this position, right, this trustee is a position. This position becomes vacant. And so in the trust, they are going to have some successor trustees, right? And what happens is those successor trustees just come in and they fill the position, and they let the third party knows that they are in that position by showing them a death certificate as well as evidence of the trust. And that way they can sign on behalf of the property that the trust holds. So in this instance, maybe they have Dan as the primary trustee. Maybe they have their attorney as the fallback, and then maybe they have somebody else as a third, right? Anyway, so that's how they get around this. So they're gone, and the successor trustee steps in. Now, the successor trustee is not a grantor, right? So grantor trustees have special powers. They can do whatever they want. But successor trustees have a limited set of powers that's more delegated to this position managing these assets. And once they die, this trust becomes what we call irrevocable. It means it can't be changed or altered or amended. And basically, it's the job of the trustee to carry out the terms of the trust. And so, in that sense, It acts a little bit like a will in that they just act as this personal representative or executor, sometimes we call it. And they're there to carry out those terms until the trust has been liquidated, and then everything just goes away. But the benefit of this is that the trustee has immediate power, right? They have immediate power to distribute those assets and take possession of them. There's no going to the court, there's no going to the judge, and then waiting the 3 months. Okay, it's instantaneous. And if they wanted to, they could arrive on site, read the terms of the trust, and start, distributing assets, 2 minutes after, right? If they were all ready for that. And so people like that quite a bit better. They enjoyed the fact that, there's not a big rigmarole and it's private, so it doesn't get filed with the court. And a trust is a little bit more flexible as well. And that flexibility would be another explanation, so we won't go into that here. But that's the first part, right? That's the what do we do with our stuff explanation. The second part is fairly simple, and that is, how do we handle our incapacity, right? If we can't make decisions for us, then we obviously need someone to step in. And we take care of that with 2 different documents. One is a financial power of attorney, and the second one is a medical power of attorney, or what we call it, an advance health care directive. The financial power of attorney basically says, this is my agent, and it is, and they're empowered to make decisions for me, both now, usually when it's a spouse. We can write these either way, but typically they'll give their spouse immediate power now, and to make financial and transact on their behalf. And then if their spouse is unable or willing, then we also have these, successor agents, 1, 2, and 3. So for when Doyle's incapacitated, if Diane is unable or unwilling, and then it might go to Dan, or it might go to an actual attorney, or it might go to a brother or something like that. The Advanced Healthcare Directive has 2 parts to it. It's kind of got an A part where you let your wishes be known, right? You tell them how you want treatment, so they don't have to make that call. When to pull the plug is a difficult decision, so you want to give them guidance on when you feel that's appropriate. And B, you designate an agent to go ahead and make that decision and carry out those wishes. Well, that is the general discussion of kind of what and how we take care of this estate planning stuff. There's 3 levels of estate planning. Right, there's the no will, which is the probate plan, and then there's the will plan, and then finally there is a trust plan. Within that trust plan, there's ancillary documents as well. We'll have a pour over will, and what that does is it's a final funding of the trust after someone dies, and as long as that funding adheres to these 2 rules, then it works just fine. We said that will needs to go through probate except for the $100,000 of the real estate. So as long as all the real estate and most of the assets are in the trust, this pour over will put all the miscellaneous stuff. Maybe it's a new car, maybe it's some tools, maybe it's some art. But as long as that values, that less than $100,000, and there is no real estate that's outside of the trust, then that works just fine.